Justine.
Thank you, Madam Speaker. I want to start by saying that I absolutely support worker safety. I believe frontline workers and all workers, including unpaid workers, have the right to be safe at work and protected from physical and mental harm. Like every person in this chamber, I believe that all Territorians have the right to be safe. We've heard many detailed stories in this chamber about harm being done to people at work, and I could also share many of those stories. I don't think we need to hear any more of them there. We all know what's happening to people. But in preparation for considering this bill, I've talked with the people that this bill is aiming to protect, to frontline workers, to people in my electorate, and to workers' representatives. I'm no stranger to working with victims of crime, and I state again that I believe that everyone has the right to be safe and to safety and to be protected in their workplace. Also, as part of my preparation for this bill, I've consulted with people in the legal profession who will be implementing this law. Every single person I've talked to, just like all of us, is concerned about worker safety. And every single person I talked to could not see how this bill is going to work actually to make workers safer. Across the board, people were clear that workers need protection, and across the board, people were clear that mandatory sentencing will not achieve this. Once again, we are seeing a law where there is no evidence that the stated intention of the law to keep people safe will be met. I've used all the time available to me since this bill was given to us to pass on urgency, to understand its detail, to what I will be voting for if I support it. Despite this consultation and despite a briefing from the department, I still remain unclear about the detail of this bill. My understanding of it is that the amendment at Clause 7 for mandatory imprisonment of 3 months for spitting only applies to police and emergency workers, not all frontline workers. And this seems to be in contradiction to what the CLP has said on this floor. I'm not able to vote for a bill when the details of it remain unclear. It's also interesting to me that the CLP, who are talking very strongly about supporting workers and workers' rights, have not consulted with any of the unions representing these frontline workers, have not talked to the firefighters union, have not talked to the paramedics union, have not talked to the corrections union, have not talked to the nurses union. Workers, the CLP also tell me that they're concerned about victims, and people also raised with me that if the CLP were really concerned about victims, they would address the fact that victims of crime at work are not covered, that workers who are injured at work are not covered by victims of crime. Victims of crime compensation, sorry. We heard the member of Blane talk about the reason that this bill will work is because it will create a deterrent. We know that mandatory sentencing does not work to reduce crime because there is no evidence that it creates a deterrent. I agree with my friend from Fong Lim, who's committed to evidence-based research. I've not been able to find one piece of research or one piece of evidence in the hundreds of pieces of research that have been done that show that mandatory sentencing does provide a deterrent. Just here, I've got 82 pieces of evidence which I'm happy to share with anyone who's interested that say very clearly that mandatory sentencing does not provide a deterrent. I quote Justice Mildren in the NT Law Reform Committee final report on mandatory sentencing, who said the premise of those who argue in favour of mandatory sentencing is that it acts as a deterrent, and there is no evidence whatsoever to support this premise. The whole underlying paradigm of sentencing law is that a sentence involves the exercise of discretion by a judicial officer. That's what they're trained for and that's what they're paid for. And we heard Minister Edgington speak yesterday about how important judicial independence and discretion was. He said, "It is clear to me that the court already has discretion when it comes to determining whether a conviction should be made. When it comes to sentencing, the court should have that discretion to determine what to do with an offender who is brought before the court, whether it's the first time, the fifth time, or included with a number of offences." The Sentencing Act gives a very clear direction to judicial officers in how to do their job in Section 5. A sentence must be just in all the circumstance. Mandatory sentencing is the very antithesis of just sentencing. When a sentence is prescribed by law and a judge has no discretion, it undermines the integrity of the whole criminal justice system. Judges cannot do their job of ensuring a sentence is just in all the circumstances. It corrupts the system and effectively takes away the discretion of a judge as to what sentence is most appropriate in all of the circumstances. Mandatory jail terms generally serve to increase the prison population because courts are forced to jail people where otherwise they may have imposed a punishment in the community. We know our jails, warehouses and remand centres in the Northern Territory are over capacity, and this kind of policy will only increase this problem. The failure of mandatory sentencing to achieve its stated aims also comes at significant cost to public money. By their very nature, these policies divert more people into the prison system and for lengthier periods of time. The result is greater cost. By personality, by experience, by practice, I'm a person who believes in working with others, and this is what I've learned works. I've also learned that we don't need to set everything up as either or. We can look after vulnerable people and make sure that people are safe. We can preserve the fundamental elements of our justice system and protect the safety of workers. Setting these things up as mutually exclusive fails all of us. I feel like a broken record in saying in this chamber again and again that to make good law we need time, we need evidence and we need wisdom. But once again, I can't support a law which undermines our justice system and at the same time will not make any of us safer. I will not be supporting this bill today. Thank you, Madam Speaker.